Krishnaswamy, Vice Chancellor, National Law School of India, University, Bangalore. Uh, I invite our Dean and Director, Professor Purvi Pokhriyal, to say a few words before I invite formally Professor Stephen Barnes to introduce and give a welcome note to Professor Thomas Yulong Mann. Over to you, Professor Pokhriyal.
Thank you, Kunal. It's a great honor to have with us Professor Sudhir Krishnaswamy, Professor Thomas Mann, Professor Dmitry from Russia, and of course our own beloved Professor Stephen Barnes with us today morning. Today, the topic that has been chosen by our two expert panelists is very interesting because we live in the post-truth era, and it's so difficult for us to reach the truth. And when it comes to lawful, truth has been always elusive. So at that juncture, how do we develop in our students, so that they productively engage in discerning the truth? And, I'm so grateful to Professor Thomas Young Mann and Professor Sudhir Krishnaswamy, who has kindly accepted our invite and agreed to be with us and deliver a talk on a very vital issue. And it's such an important topic for law students to understand and imbibe this kind of skills of critical thinking. So I, on behalf of Nirma University and students and faculty, welcome both the distinguished panelists today this morning. Thank you so much.
Over to you, Professor Stephen Barnes.
So namaste, all fellow learners. I cannot tell you what a distinct honor it is for me to attend this forum. And I'm grateful to my colleague, friend, and sister, Dr. Purvi Pokhriyal, for giving me the great pleasure to make this introduction. And I'm stunned and honored to be surrounded by titans of their own in legal academia and all things that are good. And I namely mean Dr. Pokhriyal, Vice Chancellor Krishnaswamy, Dmitry Polnikov of the Higher School of Economics, and of course, Thomas Mann, whom I now introduce. I've known Dr. Mann for well over 14 or 15 years, and it started with a cold call, literally a cold call, when he was a partner at Baker McKinsey in Beijing. And when I was teaching there, I wanted to get the insight of one of the great practitioners in transactional law, and Dr. Mann, who's now my friend Thomas, he took the call, and I'm a much better person from him taking the time to visit with me. But Thomas, as his name, not his first name, but his given name Yulong, as the name suggests, he's originally from mainland China. After he completed his undergraduate studies and also his master's degree at Beijing University, at Peking University, he and his wife went to Johns Hopkins University in the United States, where he completed his PhD in legal history. Something that's very noteworthy, he studied under one of the great legal historians, Jack Green, and he supervised the still young Dr. Mann on his dissertation. And his dissertation was published into a book. And just a few years ago, in the preface to this now published book, which was originally his dissertation, Jack Green, the Professor Green, wrote that any serious student of US legal history must read this book. And I can't think of a compliment than a dissertation becomes a book that becomes still even relevant 30 or 40 years later. But Thomas, after he completed his PhD, went on to Indiana University, where he completed his JD, and then he had a very distinguished practitioner career in Chicago at Baker McKinsey, and then he worked for several international law firms in China over the course of 20 to 25 years, including Baker McKinsey, at Lovells, and Morrison and Forster, where he completed some of the largest business transaction deals that have ever happened in mainland China, including the Ford sale to Volvo and bundling one of the largest energy deals that's ever happened in Asia. But the way I really know Thomas, though, is that at heart, he really is an academician. And he's that rare breed of a practitioner who I think at his core is a professor. And today he's going to share with us his perspectives on legal history. And I know for many of us, I think Professor Dimitri can probably speak to this as well as I do, when we're in this area of constitutional law and legal history, it's always been that yawn, go to sleep kind of subject, which is not really appealing sometimes to students because it seems to be so theoretical. From my perspective as a US citizen, I would tell you this is a subject that is more relevant now than I even believe some of our more narrowed subjects, such as mergers and acquisitions and contracts and tax and all these other things that become part of our toolkits. The reason why I say that is that, constitutional law, we've learned in the United States how important it is to become a student and a learner of constitutional law through the events of the last year. And I think you really cannot appreciate constitutional law. You cannot even begin to understand that unless you have some view of legal history. So I know that Dr. Mann will share his perspectives, but I'm delighted that this subject has become ever so more relevant today, and there's no better person to talk about it than my colleague, my friend, and my brother, Dr. Thomas Mann. So with all of that, my dear colleague, friend, and brother, Dr. Thomas Mann, it's over to you.
Thank you so much, Dean and Professor Stephen Barnes, my dear friend. And also, I'm so grateful to you to introduce me to your wonderful friends in India. I do have to say that I do feel like pretty emotional at this moment, overwhelmed by the warmth of welcome and also, of course, the depths of intellectual power. So I just hopefully I'll be able to hold myself to the task of presenting what I want to share with you today in a clear and succinct way. So I think we have pretty limited time, so I will probably just start with my presentation. At this moment, I will start the screen sharing my PowerPoints. As Professor Barnes mentioned, today I'm going to talk about a topic actually, which is kind of a cross-disciplinary exploration of how to find the truth. I mean, we all, everybody, no matter what nationality or what any background, that you would agree that truth is one of the most important value propositions in human life. Let's see. Can we see my PowerPoints fine? Okay, good. So from my personal, intellectual, as well as practical background, I studied history as my first major. Then I went on to study law and then practice law. Right now I'm teaching law at Peking University, but history study is still of one of my most actually interested intellectual topic. So I try to think for myself, are there any commonalities between the field of history and the field of law? I understand that in today's audience, probably there are many legal scholars and probably law students. And I think for legal practice, finding law is one of finding truth, finding facts is one of the most important aspect of any litigation, right? Any litigation will have generally two components. First, you need to ascertain what happened in the past. That means a fact determination. Then after you have found the fact, then you will be able to apply the law. Only after that, then you will have a judgment. So without first to know fact, there is actually no law can be applied anywhere. So try to narrow my topic today to one question, which is, how do we find what happened in the past in given time and place? First, from a pretty theoretical or philosophical perspective, you have the ontological question, which is, what is the nature of the past facts? When we're talking about the past facts, people also will associate facts with the central quality of a fact, which is truth, right? Something which is true, then can be called a fact. Otherwise, it's not a fact. There's no such a thing as a false fact or alternative fact, right? As we have heard in the US politics lately. So that's first ontological question. And secondly, you have this epistemology logical question, which is how, from practical perspective, for us living in the present time to get to know really what happened in the past. So this is the epistemological issue as to how to acquire knowledge about anything. In this here, particularly, how to acquire knowledge about what happened in the past. And this issue has been naturally picked up by scholars, thinkers, practitioners from all kinds of disciplines, okay? From natural sciences, natural scientists, in order to conduct their scientific research, they oftentimes know what really happened in the past as to the natural objects or our natural existence. And also different fields of social sciences, economics, political science, sociology. In order to conduct contemporary study, you also need to know the historical events, historical occurrences. And history study, historiography, which is a field, and some scholars will say that is between social science and humanities. But history has a very clear objective. No matter how you study history, what do you think the history as a field, the meaning of history, how to interpret history or to ascertain the significance of history. The first thing every historian must do is to find out what are the historical truths. You need to know the facts. And then that will bring us to law. As just mentioned, any judicial trial, two tasks. First, you need to find what happened. If somebody is charged with a crime, then the first thing you need to do to bring in witnesses and to present evidence to show that that person did act, commit the crime, commit the acts that are deemed to be under the legal code as acts of crime. So need to find out again what that person, the accused, did in the past. So in that perspective, I believe there are pretty much very substantive commonalities between history on the one hand and law on the other hand, because first, fact-finding is fundamental for both fields, and also they are the foundational basis for any explanation or judgment could be drawn based on the facts. And also from practical perspective, fact-finding in both in history study and judicial trial is actually based on indirect information, because for a judge or under some systems you have a jury, judge or jury will be so-called the fact finder, will have the power to determine what happened in a specific trial. But those people will have no personal knowledge as to what happened to the past. They need to acquire this knowledge through the information provided by witnesses or by the parties, and the party present witnesses as well as other material information. Historians, same thing. No historian lived in the past by her or himself. In order to know what happened in ancient India, current historian need to gather materials, right? Either materials in written form, like sources, books, ancient books, or archaeological effect, right? Unearthed from a tomb or somewhere, right? And those materials will become so-called sources for the historian. And the historian will rely on those indirect sources to reconstruct the image of past facts. From this two commonality, from a practical methodological perspective, both activities, historian and a judicial trial, will utilize a central reasoning tool, which is actually to draw inference. Here the concept is inference. Because you don't have personal knowledge of what happened in the past, what you have is only so-called indirect information. But from that indirect information, you need to make kind of leap of thought to make a reasoning in your mind to infer there is something had happened. So basically, is so-called evidence inference reasoning process. What you have is evidence in front of you. What you want to know is that to draw a conclusion about something which could be indicated by the evidence. But in order to bridge the gap between evidence and the conclusion, which will be the fact, then you need an intermediary reasoning process, which usually people call it inference. So basically, the process is for fact finders in history study will be historian herself, and in a judicial legal trial will be either judge or a juror to derive rational belief in past events based on second-hand information. Such a second-hand information in historical study will usually be referred to as sources. But in law, they call it evidence. That's basically what evidence law is about. Of course, there are also very substantial differences between the fields of history.
Professor Mann, sorry to interrupt you. I guess the slides are not moving.
Slides are not moving.
Yeah.
It's moving now. I'm sorry.
No,
Not moving.
I could only see the first slide titled Fact Finding.
Oh, what happened?
May I, sir, there is an arrow at the bottom of 1/12 is there. So you may click on that arrow and slide will move.
Should I? Let me redo this, probably. Can you see the move?
Yes.
Change of slide?
Yes, sir.
Okay. Sorry. This is the first slide I discussed. I covered this one. I'm here. That's third slide. Differences between historical study and law. First, very obvious, which is the status of fact finder. For historian, him or herself will be a fact finder, and that person, a historian, will be a private intellectual, right? There's no official duty or anything, and she's there just to pursue her intellectual interest. But fact finders in a judicial process, either be a judge or a juror, they will have the legal authority. They are actually authorized by law to be the fact finder, to be the people with the legal authority to ascertain the facts in the judicial process. That's one major difference. The second difference is that the limitations of time. For a historian, I mean, if you do not really care about your tenure promotion or any other self-imposed any deadline for your career or for your life, and theoretically, a historian can spend his or her life to write one book, to find out one fact, right? You don't have any kind of officially imposed deadline on your agenda. But that's different for a judge. A judge or a jury, they must actually make a determination about what happened in the past in a given period of time, because any trial cannot really last forever. Secondly, the third part, for the scope of a fact to be ascertained. In judicial trial, the scope of facts to be determined by either a judge or the jury are actually strictly defined by law, based on substantive law. Because for any the crime or a civil lawsuit, you all have the legal definition of one legal action. And for that specific legal action, you have a specifically legally prescribed facts. For example, murder, right? Then you must find somebody was killed and the defendant committed the act of causing the death of the victim. And if it's a murder, you also need to find out that the defendant committed the killing with intent to cause the death of the deceased. So in judicial process, all those facts are predetermined by substantive law. You don't need to look for any other facts. Historians do not have this kind of legal prescription in front of them. They can actually, based on their intellectual or research agenda, to define what facts they need to ascertain. And fourthly, finality of fact-finding. Historian can write a book about certain historical events happened in the past and make some fact findings as to who really did what. But there's no so-called legal authority on that fact finding. Basically, that will be opinion of a historian. There will be no contemporary impact, direct impact on any person or any group. But that's different for a legal fact-finding. A legal fact-finding will directly lead to consequences for either individual or a group who are involved in the litigation. In addition to that, I think most importantly, from methodological perspective, that is my focus for this brief presentation, will be there is a major difference in terms of the mode of proof. When we talk about the mode of proof, I'm referring to in what way that the evidence, inference, reasoning process has been utilized by the fact finder to draw conclusions about past facts. For judicial trial, the entire process, I would say, is rule-based proof. Entire process, you have to go by a body of very complex rules of evidence, procedure law, as well as substantive law. For example, on qualifications of either the evidential materials or the witnesses to be called by the court, there are legal criteria. Not everyone, not all evidential material can be actually adopted by the court. And also, you have the issue of admissibility, so-called evidence. There are, for example, in US context, there are very extensive rules about like hearsay evidence, about character evidence, things like that. Very, very extensive rules of admissibility. And if you watch a trial, I think would be similar probably in India, if I can imagine, because I understand India also adapt some extensive adversarial judicial trial mode. And you will see a lot of information, evidence proffered by one party brought to the court will be objected by the opposing party. and the judge will make determination as to whether such evidence should be admitted. And also, in terms of sufficiency of the evidence, there are also some rules, but compared to admissibility, the rules are very, very minimal. As compared to history, this difference in mode of proof is very, very drastic. For history, historians, as nobody can tell them, okay, this is source, this information, this evidence is inadmissible. You cannot use them. No such a rule. And a historian will feel free to use so-called the natural reasoning process to conduct his or her intellectual study. As compared to judicial trial, I would say that is because it is so much based on different extensive rules, is somehow a kind of so-called unnatural reasoning process, or you can also say it's artificial reasoning process. Now here, to illustrate my point, I want to use an example, and I picked this one not because this one is anything unusual. It's just happened to me. I'm kind of a little bit familiar with the historical background of this person and the incidents around him. So I use this as illustration. So nothing special about this person. This person I'm using is Aaron Burr. He was the third vice president of the United States from 1800 to 1804 under President Thomas Jefferson, the author of the Declaration of Independence. Aaron Burr was also at that point was very well-known founding father, along with Thomas Jefferson, George Washington, and the second person I'm going to talk about is Alexander Hamilton. Alexander Hamilton, as most people probably know, was actually the first finance the treasurer of the United States under President Washington. He basically single-handedly established the financial system for the United States, was a well-known politician, of course, of the same age as Aaron Burr. But what happened between them, they were actually fellow lawyers they knew each other early on. They collaborated in legal cases, and also they were both politically active in local and national politics. But they developed into different political camps in their political life. And their relationship came to a very tragic end. And in 1804, because of some public comments made by Alexander Hamilton about Aaron Burr, about his character, Aaron Burr actually, according to the custom of that age, issued a duel challenge to Hamilton. And Hamilton accepted the challenge, and there were a lot of drama leading to the final act. But anyway, so one day, these two gentlemen actually conducted the duel. And because according to the rule of the duel of that time, and nobody should be actually present. And they both have aides, but both of their aides cannot really see what actually happened between them. They kind of have to hide behind the bushes, only hear what happened, but not really saw what happened. What happened is that, well, both burn according to the rules, draw their against each other and fire at each other. And then afterwards, Hamilton was shot. Afterwards, he was taken to the friend's house and died next day. So as to this historical event, it's almost more than 200 years ago, and as to legal judgment, as well as to so-called historical judgment, have had like endless debates in both fields. Okay, there are probably two questions people always ask. First one is, did Aaron Burr kill Hamilton? There was no chance for a court to make this determination. And afterwards, Burr was prosecuted because jury at that time was illegal. And Aaron Burr was actually prosecuted by New York State and New Jersey State, but the prosecution never initiated actual. They charged him, but they did not start the actual prosecution. So there was no chance for a judicial trial. There's no judicial decision on this issue. But for historians, there has been a general agreement, which is yes, Aaron Burr did kill Hamilton. This pretty, in terms of historical determination, is not a hard question. But a question, because Burr was charged by New York prosecutor of murdering Hamilton. Again, judicial decision on whether he actually murdered Hamilton. But for history, there has been disagreements because kill doesn't necessarily mean murder. And 3 years later, Aaron Burr was actually involved in another incident. And he was actually, as a former vice president, was charged by US Attorney General as committing treason against the country. There was a high-profile trial, and which was actually presided by Chief Justice John Marshall. And after like over a month of judicial trial, he was actually acquitted of the crime of treason. There is seem to be a judicial decision on the fact that whether he committed treason. The judicial answer is no, but history has not reached any agreement on whether he actually committed treason. What I will focus with this illustration to bring us back to the evidence inference reasoning process and put this Aaron Burr incidents into this reasoning framework, and to find out how historians and jurists reach their decisions by both using the same reasoning device. Okay. Evidence inference reasoning is a practical analytical tool to guide the proof at the practical level to find out what really happened to the past. So for history study, if you are a historian, you from very start of your craft, you have learned that, okay, you have to be able to gather sources, to be able to do critical reading of the sources, and be able to evaluate and verify your sources. So you start with the process of, well, I have some guess as to what happened, which will be the starting point. It's a hypothesis. Okay? For example, hypothesis is that Aaron Burr murdered Hamilton. And then you need to use your sources and going through the analytical process of so-called source criticism, do your selection of sources and to analyze the content of the sources, whether they are rational, believable, or coherent, and whatever the different, the criterion that historians will adopt for his analysis. And then through this process, then you will be able to draw a rational inference from only the trustworthy sources. Then use that, you will be able to verify your initial hypothesis. And then you can reach your conclusion through objective evaluation. And you either will accept, reinforce your initial hypothesis, or you will reject your hypothesis, or sometimes you will modify your initial hypothesis. That's the process. For a judicial trial, the reasoning process is pretty similar, even though the external environments are very much different. So in the judicial trial, usually you will start to formulate so-called proposition, basically is a hypothesis. And such a proposition will be, as I mentioned earlier, will be supplied to you by the substantive law. For example, the law of New York State at that time will provide what are facts needed to be proven in order to convict Aaron Burr of the crime of murdering Alexander Hamilton, right? And then you need to gather and utilize all available evidence to prove that initial proposition. The proposition in the judicial trial will be by the prosecution as elements of to be charged against the defendant. And then you have evidence. The evidence, you have to go through the process of admission by the court. And there are legal criteria as to the admissibility of specific evidence. The most important one is so-called relevance. The evidence must be relevant. Relevance means, of course, we don't want to go to details of definition of relevance, and mainly mean that must be at least minimally probative, as well as the evidence must be material, must be important to find out the essential element of the legal claim. But some evidence will be excluded at this point. Sometimes not because such evidence is not relevant. It is relevant, it's highly relevant, it's very useful for proving process, but because of other policy consideration. For example, if the evidence has been collected by police using illegal means, that evidence is very good in terms of the ability to prove defendant's crime, but because of policy considerations, and the law should not encourage police to use illegal means to gather evidence. Then, at least in the US, the decision is that, well, such evidence, even though it's highly relevant and probative, they should not be able to be used by prosecution in the judicial proof process. So because of this screening of the evidence, what the juror in the US would hear the evidence, well, they have only partial of the evidence in front of them. Based on such screened evidence, then the fact finders will be able, based on whatever the evidence they have heard, to make rational inferences to either support or negate the fact, so-called consequences, as the essential elements of legal claim, which will be supportive of the initial proposition. And then that will be naturally a decision can be made by the court. Here I draw my interest to my own research interest, and also I highly recommend this book by three professors from different fields. And the book is called Analysis of Evidence, and published in 2005 by Professor William Twining, is a British legal scholar, and also a trial lawyer, Terence Anderson, and the author who is a scholar of mathematical probabilities, David Schwann. And they co-authored this book and put forward, I think, in my view, lots of great insights as to the process of judicial proof. And from their insights, I think there is one particular aspect that struck me as very, very instructive, because they observed that in order to find what happened in the past, in order to be able to effectively utilizing the evidence inference reasoning process, it's very important to master the skills as to how to be able to simplify the complex proposition into simple propositions. What does that really mean? First, we start with a question, either for a historian or a court, as to what facts we need to prove in a judicial process. I mean, usually you are asked to be to prove a simple fact, whether somebody did something. For example, whether Aaron Burr killed Hamilton. And this is an act, a human act. A human act can be observed by others through their senses, like either vision, either smell, either touch, or either hearing, right? So for this kind of facts, I would call it elemental fact. It's a human behavior in the form of a kind of objective action or a status. But in addition to elemental fact, there are also many other kind of facts which are not so simple, because a lot of times you are asked to ascertain a fact which is a combination of first an action like kill someone and a mental state, for example, an intent. If you ask a question, did Aaron Burr murder Hamilton? Murder itself, which is different from killed Hamilton, which implies at least first there was an action, used some way to kill somebody. But not only he killed Hamilton, but also in carrying out that action, Aaron Burr's mental state was that he intended that consequences to happen. So most of the cases in legal actions, they are a combination of physical action and a mental element. So I call this kind of facts compound fact. Many facts cases, either judicial trial or historical research, are those kind of facts. And those kind of compound facts usually will provide most difficulties for a fact finder. As I mentioned, analysis of evidence, they had this insight in order to be able to find out what happened in the past when the past act or the fact is a combination of action and intent. Then what you need to do is to be able to simplify the complex proposition. Here, compound fact actually is a complex proposition. And you find a way to simplify the complex proposition into simple propositions. Let's look at one example. For example, in this case, did Aaron Burr murder Hamilton? Which is, as I mentioned, is a compound fact. From analytical perspective, what a fact finder need to do is to subdivide this compound fact, this proposition, into intermediate and, if possible or necessary, sub-intermediate propositions. For example, this question, did Aaron Burr murder Hamilton? You can subdivide this proposition into, well, if we are talking about murder, there must be a killing took place, right? You need to find out independently, did Aaron Burr kill Hamilton? Secondly, did Aaron Burr intend Hamilton's death? Okay. For the first one, probably it's much easier to ascertain from witness accounts, from historical evidence, from ballistic analysis of, for example, the bullet that killed Hamilton, whether that bullet came from the gun, the pistol of Aaron Burr did fire, right? For those kind of things, you can use scientific means to ascertain. But in terms of intent, how do we prove somebody's intent, especially that intent took place in a historical time? Then what you will need to do, you need to subdivide your inquiry into simple elemental facts, which that can be observed by the outside action of, for instance, Aaron Burr. For example, you probably want to subdivide this intent issue into first, Aaron Burr hated Hamilton. That will provide you with a motive, right? What evidence you can present, for example, you can find out from historical sources, Aaron Burr told others that he hated Hamilton, right? He said that to others. That's one evidence. And also you can find facts about Hamilton destroyed Aaron Burr's political aspirations. This is also something you can ascertain from existing historical sources. From such kind of information, then you will be able to make an inference, which will be a rational reasoning process. While Hamilton destroyed Aaron Burr's political career, and he really hated Hamilton. Well, you probably can draw an inference, which is reasonable inference. Burr hated Hamilton, right? And then, second elemental fact, for example, you can try to prove that Aaron Burr used a deadly weapon against Hamilton, right? So evidence, what evidence you have? Well, Aaron Burr shot Hamilton with a pistol. And then you can identify the bullet Aaron Burr used was of the nature capable of causing Hamilton's death, and so on, and so on. Then you will be able to probably draw an inference. Because of that, Aaron Burr intended to kill. Because Aaron Burr will now tell that I intended to kill Hamilton. But from such evidence, you are permitted to draw a rational inference. Aaron Burr intended. Of course, in the process, as it happens, you will always see opposite evidence. For example, in this case, there are evidence that shows that Aaron Burr actually, after he found out Hamilton was shot, he was really genuinely shocked, which might be interpreted as that, well, he didn't think that he really wanted to kill Hamilton. That's also a reasonable inference to be drawn from this fact, evidence, right? So that's why, because of this, it's very complicated to really determine whether Aaron Burr did have the intent to kill Hamilton. But that's the reasoning process you will need to go through. In terms of judicial trial, then the fact finder will need a determination based on what you have, whether the evidence that lead to reasonable inferences can meet the legal standard. For example, this is a criminal trial. The standard will be a reasonable doubt whether such standard has been met. If yes, then, well, you can convict. Otherwise, you have to acquit, right? For history, of course, historians have been discussing this, debating this ever since the day after the duel between Aaron Burr and Hamilton. Well, that will bring to my, I think, the concluding part of the presentation. So for historical study, as I mentioned, is generally a natural reasoning process. And natural reasoning plus a free proof process. There's no legally prescribed standards procedure for a historian to follow. And oftentimes, fact-finding is a fundamental part of historical research, but after you have adopted one fact, then a lot of historians will think that, well, I will move on to explanation, what causes to event, or sometimes move on to explicate so-called the historical meanings, even at the impact to the future generations, right? That's all what a historian can do. But in terms of fact-finding part of historical research, in my view, historians need to actually enhance their fact-finding procedure by adopting some of the techniques or procedures developed from other fields. And the enhanced fact-finding, which will actually improve the actual truth, historical truth, then will promote freshening interpretations and enriching historiography in general. For judicial trial, as I mentioned earlier, different from historical research, is not all natural reasoning process. It's rule-based and is a lot of times, a lot of aspects are artificial. And fact finders basically cannot use all evidence available. And some evidence which is very good for other reasons outside truth finding will be excluded from the evidence pool. That is different from historical research. And for this reason, judicial fact-finding reasoning process is very much kind of artificial process. There are complex rules to control risks of inferential reasoning under system constraints. And also because, very importantly, serve social values of a judicial trial other than accurate fact-finding. For example, judicial fairness, that's the essence of judicial justice, and must be fair. And also judicial efficiency, the time limitation. You cannot have a trial forever. And because of that, and the lawyers, judges, and sometimes, of course, jurors are under kind of very much pressure to develop systematic rules to enhance their fact-finding process, because they don't have the leisure of time. They don't have actually the ability to access all evidence. Some evidence which is probative will be excluded. Because of that, the judicial process, the participants in the judicial process will find that higher need to identify effective methodological tool to enhance fact-finding. So because of that, evidence, inference, reasoning process, as I just mentioned, if I can modify this reasoning process to divide facts into elemental facts and compound facts, especially to adopt the advice from this brilliant book, Analysis of Evidence by legal scholars to simplify compound facts into elemental facts, then that will make the judicial fact-finding more effective, efficient, and also at the same time will not sacrifice the truthfulness, the fairness of the process. So in that sense, I believe that this model, this analytical tool should be in some way borrowed by historians, if possible, to utilize that into historical research. So by doing that, the so-called the cross-disciplinary fertilization, I think, will be able to enhance the further development of both disciplines. I think that's the end of my presentation. Thank you very much for your patience.
Thank you, Professor
Mann, for an insightful presentation. You reminded me of a very remarkable essay by a historian called Carlo Ginzburg and his famous article, The Judge and the Historian. The way you tried to, I'm just rehearsing the argument that we can have a better and informed discussion during the question and answer session. You made a point about constructing difference in terms of how historians' reasoning construct proof and how legal reasoning constructs proof or reconstructs proof. We would take up this question of construction of historical reasoning and legal reasoning and the way the proof, the evidence, the truth is constructed in the Q&A session. Before that, I invite Professor Pokhriyal, our Dean and Director, to introduce and invite Professor Sudhir Krishnaswamy to speak on seeking truth in history and law. Over to you, Professor Pokhriyal.
Thank you, Kunal. It's a great pleasure to introduce our speaker, Professor Sudhir Krishnaswamy. We all know Professor Sudhir Krishnaswamy is the Vice Chancellor of National Law School of India, University, Bangalore, and probably the first alumnus of any National Law School to occupy the highest academic leadership position of any National Law School in India. Professor Sudhir is also co-founder and trustee of Center for Law and Policy Research, which is a not-for-profit research trust. Professor Sudhir has pursued his LLB degree from National Law School, Bangalore, and thereafter he read his BCL from University of Oxford. And from the same university, Professor Sudhir has pursued his DPhil degree and has a short stint as a teaching fellow at University of Oxford. Professor Sudhir also taught at National Law School, Bangalore and National University of Juridical Sciences, and also had a Center for Public Policy and Governance School at Azim Premji University. Professor Sudhir is a very renowned and outstanding scholar of constitutional law in India, and has also authored a book on democracy and constitutionalism in India, which was being published by Oxford University Press. It's a great honor to have you, Professor Sudhir, with us. Over to you.
Thank you, Professor Pokhriyal, for the kind invitation to be a part of this panel. I noticed from your invitation materials that you've organized as many as 43 of these panels or something like that, which is a very impressive and significant effort. And I'm sure that your students and your faculty colleagues, as well as others, have benefited from this exercise. I know that you've done very interesting work at Nirma Institute of Law over the years, and I look forward to having the opportunity to visit and learn more in person. So Kunal Kishore has helped put this together, at least from my perspective. Thank you for organizing and facilitating my participation, and I'm glad to be here. Dean Stephen Barnes had a very warm conversation this morning. Thank you for the warm welcome and the rather impressive list of 300 students and others in the who are participating, I know that despite my best efforts, I would not be able to do anything close to this in my university. So hats off to all of you in the organizing team to bring the students here this morning. And I hope that our conversation helps you work out some intuitions and ideas that you might have about a topic like this. We are gathered here this morning to engage with Professor Mann's compelling presentation on the relationship between historical truths and legal truths. I'd like to engage with these themes further. I only propose to extend some of these themes and maybe evaluate some tensions that might emerge from these categories. I hope to also apply some of these intuitions to recent debates, both academic and legal in India, which might be a useful precursor to the question and answer session to follow. I take it that I have between 10 and 15 minutes, so let me rush along.
You have more than that. You have more than that.
Okay. Okay. So let me see. I'll let you call time on me, Kunal. Whenever I've gone on too long, please just signal that to me. So Professor Mann began this morning setting out elaborate schema for us to try and understand the ontology of facts and the epistemology of facts, and suggested rightly, to my mind, the distinction between legal and historical ontologies and epistemologies. We might make a commonplace assumption that ontology and epistemology of all things, all facts, are universal, that they're the same, no matter what our disciplinary or our modes of knowing may be. And I think Professor Mann began well this morning by reminding us, alerting us that this may not always be the case. And we would do well to pay attention to the different ways in which we know. This is why we have the disciplines, and sometimes there are gaps between disciplines, and there might be in some senses concentrated truths, truths in one discipline which may not extend to being truths in others. Now, a grounding problem that I thought he began with was the sharp and astute observation whether we can move from facts, how we move from facts to truth. In other words, do facts under or over determine the truth? Do we know enough about a factual circumstance for us to be confident about the truths? And here, when I think about truths, I mean our beliefs about what happened, to be under or over determined by the facts. Now, in the law, as he clarified for us, we have a very elaborate procedural and evidentiary apparatus to help us determine exactly how much fact do we need to arrive at a particular truth. We often speak in terms of beyond the reasonable doubt standard in the criminal law, or a balance of probability standard in the civil law, to help us establish exactly what level of determination do we need from the facts to truth. And the common law, and I'm relying on common law assumptions. I know that in China, the legal system is more complicated, but even working within the common law, the legal system can be quite explicit about the nature of probabilities required for us to move from fact to truth. I think he was right also in pointing out that that historians have a less than structured method in this respect. I'm sure historiographers would object, and they would insist that that historiographers, at least good histories are those that take very seriously the move from fact to inference. Yes, there are bad histories as there are bad cases, but what we do know is that the historical method is less, let's just say for the moment, systematic. It's less systematic about the relationship between facts and truth. all of this, I think, is well said and well put, and broadly agreeable, I trust, to most in this audience. But I'm going to move now to a different tension that I think Professor Mann would agree is one that we must be alert to and engage with in our contemporary moment. This is the rather subtle but um, uh, large shift from a correspondence model of truth to more coherence theories of truth. It appears that in the popular as well as in the academic, we are moving away from the idea that truth inferences must be made from facts at all. And let me clarify this in just in a very simple way. I know that we have many students in the audience, so I won't try and build a philosophical argument as a more generic one for this morning. A correspondence model of truth is one that that confirms true beliefs to be those that have a certain relationship to facts, right? That beliefs based on the existence of several facts that confirm the same belief would be a true belief, right? So a correspondence theory of truth is embedded into the legal system. The evidentiary process as well as the procedural law try to advance both correspondence truth as well as some dignitarian concerns of fairness that Professor Mann uh, uh, referred to. So we try to achieve two things. Let's establish the truth, not at all cost, because we have some fairness considerations. So even when we could extract some kinds of truths about belief, about intention through torture, we don't do that. We don't do that because we care for the dignity of individuals. So with some constraints, the legal system encodes this correspondence model of truth. The popular discourse, at least in large democracies with kind of disparate media structures, appears to have moved from this correspondence model of truth. We seem to now rely on coherence models where the truth of our beliefs seems to rest on what other beliefs we have. So what really matters then is that the set of beliefs that we hold, the entire basket of beliefs, are coherent amongst each other. No? Vis-a-vis each other, the beliefs are coherent. That they may or may not have correspondence to the facts is something that is set by the wayside because we can't seem to agree what the facts are, right? So this is a slightly different problem, and let me raise this problem up front so that it's something that we remain alert to, and I think it's very important in at least in an Indian context where we are grappling with this problem at the core of our democracy, our politics, and the law. And so we would do well to pay some attention to it. I'm going to take up 4 instances where I think this problem arises in very different ways and with different results. All of these instances are instances where historical or social truth seems to diverge from legal truths with different results. And I'm going to just lay these out more as examples, thought experiments that we might use as we think about this problem at greater length. Let me begin first with a recently decided case where the Supreme Court of India tried to settle the Ayodhya dispute, which relates to the construction of a mosque, arguably on the ruins of another religious structure, which gave rise to a large political movement in India and corresponding litigation, which, as these things happen in India, took an extraordinarily long time to wade its way through the district courts of the Uttar Pradesh, finally making its way to the Supreme Court of India. What is striking about this case is at its core, it was framed, at least in a legal sense, as a property dispute. A property dispute where several claimants made legal arguments for why they should have a priority claim, a priority interest in the property. As we know, in Indian property law, common law property law, with the relative, which adopt models of relative title, the priority in time can translate into priority in interest. Now, what is astonishing about this case was not the proposition of law. What is astonishing about this case is the historicity of the claim. The historicity of the claim arguably stretches back 5 centuries. Now, really, can a court of law in the 21st century reach any legal truth determination about the priority of claims stretching across this period of time? Now, the close reader of the judgment would remind me that, look, the court doesn't have to go that far. It only needed to settle the question around 1950 and thereafter. And I think that's a fair point. But the point I want to make is, in this case, the facts, and to be fair to all parties concerned, underdetermined the truth. Not only historical truth, not only could we not make robust historical truth claims, that we might all have different intuitions about what level of probabilities was sufficient for the historical truth claim. But I can tell on the legal truth for sure that there was a poverty of facts, and the facts that were available had all kinds of difficulties in establishing them. Now, what happened in the case? What is very interesting about this case is that, ironically, the court agreed that on the question of facts, that the claim that there was a pre-existing Hindu religious structure could not be established. They reached that conclusion. They said, on the available evidence, we can't say that there was this structure that existed. But in law, the court held in favor of the proposition that the parties that claimed that a Hindu religious structure could existed in that particular site would have a priority in law. So it's a very interesting judgment where the court reaches 2 different conclusions. One conclusion about where the historical truth lies, and another conclusion about where the legal remedy must lie. And there was a sharp divergence between the 2 conclusions. And it allows us to think very clearly about what is the nature of this disciplinary production of truths, right? That legal truths and legal outcomes may not always align with historical truths and historical outcomes. This is something I am not putting forth as a justificatory model of adjudication. I'm just raising the very interesting proposition that Professor Mann began this session this morning, that we must think about the different modalities by which truths get established. Let me move on to my second example. My second example is in a very different sphere of law, rape trials. Pratiksha Bakshi, in a very important and interesting book called The Public Secrets of Law, Rape Trials in India, tries to explore and explain a significant phenomenon in India, that while rape trials begin on the basis of a complaint of a victim, as these trials wind their way to the legal system, often acquittals result. And what is more astonishing is that often acquittals result because victims or victims' families turn hostile in the evidence process. Based on her substantial ethnographic fieldwork, including in the state of Gujarat, where the Nirma Institute is, she finds that this production of a legal acquittal is not something that the participants in the trial don't know. They all know exactly what is happening in this case. So as far as the social truth, that is the beliefs and the knowledge of the parties concerned, they are all fully aware what is occurring outside the courtroom. But as far as the formal record of the courtroom is concerned, a particular legal truth is produced. And the legal truth in this case being acquittals. The social production of this legal truth is one that never finds its way into the legal record. Right? Nevertheless, the social truth is well known to all parties. Right? It's produced by traditional structures of patriarchy and caste and so on, which allow for a particular social truth to somehow never establish itself in the courtroom. Now, what I want to point out here once again is our ways of knowing the truth. And if we ask the question, what is the truth about rape trials in India? We would reach the conclusion that a majority of them, very large majority of them, result in acquittals. And if we stopped there, we would understand just a partial account of the nature of these trials. We would not understand the truth of the social context in which these legal truths are produced. So in this case too, there's a divergence between social truth and legal truth. The social truth would lie a little closer to a correspondence theory of truth, not the legal truth. We imagine that the rules of procedure and the rules of evidence allow for the law to produce higher truths, right? This is a common assumption we make, which is why we invest so much in a rule of law system. But in this kind of case, we see a systematic manner in which the social truths are actually in some sense more true than the legal truths produced by the legal system. The third example and the third instance I'm going to invite you to think about is to think through the problem of collective violence. Now, all societies across the world have experienced bouts of mass collective violence and have had to struggle with the idea of how we produce a true and accurate account of what has happened in these bouts of collective violence. I think most of us are fully aware that the Holocaust in Europe in the Second World War is the first systematic effort to both impose legal accountability for mass collective violence, as well as to memorialize and to capture the history of the Second World War more accurately than has been done at other times in human history. Now, the historical approach in the Holocaust, historical approach to the Holocaust, was one that preferred legal liability. Right. So we know about the Nuremberg trials, and we know about continuing efforts to prosecute Nazi sympathizers and actors in the Holocaust. It continues till today. We also learn, and this is the important part that I want to begin with, we also learn that the quest for legal justice in these cases can have at certain times obscure historical truth, because the possibility of legal liability keeps actors from sharing what actually happened. It also gives them incentives to obscure the truth of what has happened. And we know that there is tension between securing legal truths or convictions of certain key actors and our collective historical consciousness about what might have happened. And there's a tension between the two. We might have to, ideally we could have both, but maybe in some circumstances we can't. And we might have to choose one for the other. Now, we know that in South Africa in the 90s, the South African model of transitional justice clearly sacrificed legal convictions and truth for historical truth. by granting immunity to people who might have been implicated in the crimes of apartheid, the South African constitution makers chose to sacrifice legal liability if a fuller historical truth could be produced. It was, in their judgment, more important to produce historical truth at that moment than necessarily the conviction of one party or the other. Notice once again that collective memory or a collective common sense seems to have more long-term consequences than the particular convictions of this or that actor. Now, the Indian experience in this on this question has been abysmal, because as the book Splintered Justice by Preeti Jha and Barisha Farasat makes very clear, that whether it is the partition or 1984 or 2002 or 2020, most recently, the Indian legal system is systematically unable to deal with mass violence. Moreover, using instruments like the judicial commissions of inquiry have also not produced compelling results on this question. And somehow we seem to have neither produced legal truth and accountability, nor produced historical truth and reckoning. And we fall between the two stools on the question of collective violence, and have really struggled to deal with it and continue to struggle in our current context. So here is my instance 3, and look, as you can tell, I'm trying to show progressively how all models seem to break under certain kinds of social pressures.
Sorry, Professor Krishnaswamy, I think it's instance 4. You've already mentioned 3.
Okay, 3. Now I'm on 4 now.
Trial, 3rd was collective violence.
Thank you. And I'm on 4 now, and at 4 I stop. So I also let me signal that. This morning, I think the Delhi High Court released on bail activist who was arrested on charges of sedition, and the High Court judgment is quite compelling to read, because it emphasizes very clearly how legal epistemologies work. The judge points out that not a shred of evidence has been produced to show the linkages between the parties, that is an activist in Bangalore and some transnational parties trying to defame India or something like that was the claim of the prosecution. And the High Court judge took the view that there was no evidence at all on the record to show this. The High Court judge took the view that there was no evidence relating to any acts of violence. Now, this judgment comes against a background where there is a mass media spectacle on cases like this, where particular versions of the contemporary reality are put forth as being true. And if you ask the question, and I'm going to I'm going to just pay some attention to this as I close, is what's going on here is some tension between a popularly produced model of truth and a legal truth. And a popular truth in this case is one that is produced almost entirely by some kind of correspondence theory of truth. I have some beliefs about bad actors in the world. If those bad actors say anything or do anything, those bad actors are certainly motivated by these seditious or other impulses. Hence, this correspondence theory, my observed facts, that is the fact of someone tweeting something or someone editing a toolkit, conform to my pre-existing beliefs about the nature of these bad actors. Hence, the popular truth is that these bad actors are seditious. To this popular truth is a legal check. And the legal check models of a correspondence theory of truth. It asks, are your beliefs justifiable based on observable facts that are available to anyone who might come to this context without your beliefs, right? So you see a very strong contrast between a coherence model of truth where beliefs are tested against your other beliefs, and a correspondence model of truth where your beliefs are tested against other facts. In the context of complicated and media structures in a mass democracy, this constraint on popular truths and popular passions driven by these popular truths is critical to sustain a rule of law society as well as a democracy. And what is striking in a context like this is that very conventional, staid, in some ways you might say old school legal reasoning does the job. We don't need any high-minded rhetoric about the nature of civil liberties and the place of the Constitution. None of that. All we need is to do the work of evidence law and to just conform to the rigors of a correspondence model of truth that is already built in to our legal system. So my fourth instance is at slight variance to what I have my other three instances. My first three instances, I suggested that the production of legal truths is not always, should not always have priority, and is not always the most preeminent truth on a particular situation. In the case of mass violence, it may not always be preferred. In the case of rape trials in India, it may not always be the full truth of a situation. But in my last instance, it's clear that the legal system and its historical ability to refine the true from the untrue using a very old model, old conception of truth, where truth must be about the reasonable beliefs that we can draw from observable facts in the world, has a salutary function to play even today. It might be old world, but it has real world consequences. So let me stop there and hand back to Kunal and Dr. Purvi. I think this is an important topic, and I thank Professor Mann for getting us started. And I'm sure that as we get into Q&A, we will all learn even more as we go along. Thank you.
Thank you, Professor Krishnaswamy, for your provocative reflection on questioning the notion of historical truth and the notion of legal truth. There was a moment where you cited instances where the notions of historical truth can overlap with the notions of legal truth. And there are also moments where neither of them are produced. So they overlook legal truth as well as historical truth. Now, before students and faculty colleagues put their questions in the chat box, I would like to just understand one question, and this is a question which I asked to both Professor Mann and Professor Krishnaswamy. I was just thinking that if we look at legal trials today, and this is not my area, I teach political science, so in some sense it might be counterintuitive also to ask this question. No, in legal trials, in some cases, we are moving more towards appealing to the conscience of the nation. No, we talk about democracy, but we forget a lot of times the questions of nationalism making an impact on juridical fact-finding, juridical inquiry, and legal trials. And so long, the question of history is moving towards more objective notions of truth. No, as we all know what our past is, what our present concerns are, and where we are heading into future. So, what kind of truth then both historical reasoning and legal trial is pushing us towards what? Historical truths becoming more objective and legal truths becoming more subjective when it comes to the questions of nationalism.
So question for me.
for both of you.
Yeah. Okay. Let me try to give my 2 cents first. Probably, I have to say that I really enjoyed the commentary, and that is really insightful, and that helped me to broaden my horizon, think more deeply about the implications of truth finding in different contexts. And I would like to clarify one point is that my intended topic to be, I try to be like focus very, very narrowly on the methodological aspect of truth finding in historical study and in judicial trial. And I understand that I omitted or neglected many of the social ramifications of truth finding process from kind of empirical perspective. And I truly appreciate the insights and both of you have actually provided. And on the question of historical truth becoming more objective, and some of the other areas of truth finding or belief in truth becoming more and more subjective. And I totally agree with this observation. I think there is, I mean, at least from my perspective, I based on my inquiry into the topic, still mainly based on the traditional model of so-called truth from philosophical perspective, mainly still based on correspondence theory of the truth, but somehow supplemented by the coherence theory, in the sense that any kind of belief or interpretation of truth must also be kind of be coherent with other interpretations, all based on rational reasoning process. So you have the rigorous requirement that you need to actually to look through all evidence available, and to actually to be able to discount any, to explain any evidence that is actually show against your hypothesis. So from that perspective, I think for historical study, for historians, I think over centuries, the objective, I think, has always been to find the objective truth. Either as kind of ultimate goal or aspirational objective. It's just understand that after, especially in the post-Second World War period, after the postmodernism, and there is so much of kind of skepticism about objectivity and whether we will be able to achieve objectivity. And there are very good arguments from philosophical or analytical perspective. But still, I would still like to go back to the traditional perspective and try to still justify the proposition that there is objective truth, and the only task for all of us from across disciplines is to sharpen our methodological tools to be able to access such objective truth as much as possible, even if we probably, as a human being, will never be able to achieve such truth. Of course, in society, then there is an issue as to who can decide, right? Who has authority to decide which is objective truth. But still, aspirationally, I still think for scholars from different disciplines will still adhere to the traditional view and not to be affected so much by different, impacts of political ideology and social ideology from different perspectives. I understand that's the reality, and that has affected people's belief in so-called truth in different spheres of social and political life. But still, I'm a traditionalist in that sense, still want to be able to find the ways to access the ultimate objective truth.
Before Professor Krishnaswamy answers this question, I would just add a note to the comment that you made, Professor Mann. I pose this question precisely because there is already a debate which has been existed in historiography, especially in the Annals school of Marc Bloch and Lucien Febvre, which they intended to produce historical truth to understand. So there we are right. But Carlo Ginzburg is a position, he says that historical truth is not only about understanding, it's also about judging. So there is no difference as such. And even his traditional understanding of historical truth, he says that the production and inquiry of proof, evidence, and truth is brought both from the history of rhetoric and the history of medicine. So even today, the rhetoric fragment of production of historical truth and legal truth plays a role. So thereby I was just risking myself thinking about the contention of historical truth becoming more objective and the legal truth relying on what Professor Krishnaswamy was saying, production of social truth. Where so that was my intention to have a wager asking this question. Yeah, over to you, Professor Krishnaswamy.
Thanks, Kunal. I think it's a difficult question, and Professor Mann has, tried hard to make clear where he would stand on the question. I think there are two broad levels at which one can respond to a question like this. In our philosophical understanding of truth, there have been structural shifts in our accepted model of truth, right? So that pressure occurred maybe around the late 1940s in terms of the models themselves, but has grown in strength. In an Indian intellectual context, we would broadly say two movements, post-colonial thinking and postmodern thinking, have challenged truth production from colonial regime truths and other commonly held truths, right? So we have learned and we have grown in an intellectual tradition to be self-reflective and critical of truth production generally. And that criticality has meant that we are not terribly certain which model of truth we embrace. We seem to embrace different models of truth depending on the question we are asked often. And there is some degree of both philosophical and personal complexity to that truth question itself. But in the question of whether historians have got the better end of the stick, or whether legal theorists or legal courts have done better on this, I'm not so sanguine about this, because in an Indian context, this debate between the nationalist and the rationalist version of history is 4 decades old. It began in the late 1970s. It gathered steam in the 80s. By the 1990s, this was writ large, and maybe in the last 2 decades, we've not made much progress. All I would say is that the academic historians in India have done very well to hold their own in this debate. even when the political and social currents have been against them. And I would put that down to the strength of the historical intellectual tradition, both in India and beyond. For law, the battle has only just begun. So the question of what is a nationalist or a rationalist view of legal truth is only, in my mind, less than a decade old, maybe even just 5-6 years old. We have a big deficit here. We don't have a good legal academia. Unlike our historians who are world-renowned and who are some of the best in their field, wherever you look, we can't, with all due humility, we can't say that for legal academia. Legal academia in India has predominantly seen itself as a professional, a skills provider, and has ducked some of the biggest questions in the field. And we don't have the same strength or the same intellectual heft as the historians have had. So I think that with that kind of dim precursor, let me say that the 21st century will bear ourselves out on how legal academia and the legal system holds out against a populist nationalist pressure on truth production and its processes in the years to come. Back to you.
One last question from my side to Professor Krishnaswamy before I take participants' question. I just want to understand, if I add one more instance about the nature of fact-finding done by the civil liberties movement, especially the PUCL and PUDR, and if I look at their fact-finding methods and courts citing their fact-finding reports against the official inquiry appointed by the state, in some cases, how do you see this extra sort of constitutional fact-finding measure to the question of production of, or how does it help in the production of legal truth?
So it's interesting to think about PUCL, the People's, for those who are not familiar, the People's Union of Civil Liberties, and their fact-finding techniques. And if we ask the question historically, when did this pattern emerge? This pattern emerged in the freedom movement. If you read the biographies of Gandhi and Nehru, some of their earliest work was on contesting colonial state productions of social truth, right? So what they went,
I remember Kanpur riot, work
yes,
done by Gyan
yes.
Pandey, Professor Pandey, and the second, the Champaran report produced by
No,
Gandhi.
but all over India, they encouraged in the colonial regime a culture of fact-finding, which challenged colonial truth production. So in my mind, PUCL or someone else's work is in that tradition. I think it is the place of civil society to engage actively in questions of what is social truth. The fact that we have competing claims about a particular event, historical or recent event, is not surprising. We have a complicated society, and a complicated society produces complicated truths. We needn't be too unsettled by that. The quality of our report writing is critical. So if a court takes judicial notice of one particular model of fact finding, I take it that the court is reasonably convinced that the fact finding model adopted is robust. And in some circumstances, civil society fact production may be more robust than state fact production. In other circumstances, state fact production might be more robust. And so my sense is it depends on the context of the event and the circumstances. We don't have to be, in an a priori sense, we don't have to be too worried about that. There's nothing remarkable about that. This is very much the intellectual tradition of the freedom movement. There's nothing for us to be terribly concerned by alternative attempts to present social facts.
Thank you. So there is a question for Professor Thomas Mann by Professor Stephen Barnes. he says that, and he also informs all of us that Professor Mann was also member of the drafting committee for the revised rules of evidence in China. So his question to Professor Mann is, what role does evidence law play in the rule of law?
Oh, thank you for this insightful question. The situation in China, I really appreciate the comments about put the issue in the national context of India, and for which I hope that I wish that I had more knowledge and in order to be able to participate more fruitfully. As respect to China, the rule of law, the effort to build rule of law is it's a centuries long, but really get steam or restarted about 40 years ago. There's in the late 1970s, the opening up and reform period, and there's that point that the restoration of the judiciary and also the so-called the concept of rule of law has gradually been explained, advocated by scholars from different fields, and also accepted by public, I think, at many levels, as to law is important in social life. That's one level. But as to the concept of the essence of rule of law, as law is actually abiding force against the government action, which has not been, how to say, as widely appreciated by the general public as to the first layer of meaning that, well, you cannot have a jungle society of jungle rules. You should have a predetermined law, and everyone should be judged equally by the same set of rules. So in that process, I mean, evidence, have to say, did not play a did not really possess a kind of any sense prominent position in the Chinese judicial or legal system. And the only, I think, in the past, I will say, less than 20 years, and our legal scholars and jurists began to appreciate the essential importance of judicial proof, the approval process, as to the realization of the true meaning of rule of law. And I'm pretty, proud of myself being part of that process. And we set up an Institute of Evidence Law and Forensic Science at China University of Political Science and Law, which is the first such a kind of institute that focus on the study of evidence law and forensic science. And we help the Chinese Supreme People's Court to codify the evidence rules, which previously actually scattered around in different procedure laws, like civil procedure law or criminal procedure law, and be put aside into a kind of very, very non-prominent place. But now the concept of the judgment, every judicial judgment must be based on evidence, nothing else. This is very, very simple or fundamental concept, but think about it 30 years ago, and that was not a commonly subscribed concept in Chinese judicial process. And it's naturally for a judge to think about, okay, I make judgment, well, facts, well, important, but how to get to know the facts, of course, we saw that they can use all kinds of means. As mentioned earlier, you can use torture, right? If the torture is effective, can extract a confession from the defendant, well, by all means, you think that's truth. And also, they make judgment based on all kinds of policy considerations and other than facts. And so the basic concept of making judgment based on get to know the facts only based on evidence that is presented to the court. And such evidence must go through an adversarial process of an open court present evidence and subject to cross-examination by the opposing party. All of that actually less than 20 years old in China. And in practice, I don't think it has been enforced very healthily, but it's a good beginning, and just hopefully the process will continue. And I think that's a very large topic. I would not have time to elaborate, but I think in summary, this is a very, very recent development.
Thank you, Professor Mann. I apologize to students and my fellow participants to not take up their questions because of the paucity of time. So I'm sorry to all of you for not taking your questions. Now I invite our student Kratin Sastry to give a vote of thanks to this session. Kratin, over to you.
Am I audible?
Yes, Kratin.
Okay. Good morning to one and all present here. I, Kratin Shastri, on behalf of Institute of Law, Nirma University, would like to extend a heartfelt vote of thanks to our esteemed dignitaries, Dr. Thomas Mann and Dr. Sudhir Krishnaswamy, for delivering such an enlightening session. It was really an informative session that gave us insights on how the judicial process vis-a-vis the historical process approach the process of finding truth. I would also like to extend our sincere gratitude to Dr. Purvi Pokhriyal and to Dr. Purvi Pokhriyal for organizing these sessions and enabling us to learn outside the class. And I would also like to extend our thanks to Professor Dr. Kunal Kishore for moderating this session and the staff members for handling the technicalities. Lastly, I would like to extend gratitude towards all the students for patiently listening to the session. Thank you.
Thank you, Kratin. Thank you.
Thank you, Professor Sudhir Krishnaswamy. Thank you, Professor Thomas Mann. And I, on behalf of the Institute, convey my heartfelt gratitude for being with us. And as I said earlier, we would like to host you on the campus once the situation around us gets settled. Thank you so much for joining.
Thank you. Thank you all.
Thanks.
Bye-bye.